Hello and welcome to this edition of Inside Judicial Watch. I'm your host, Jerry Dunleavy. Today we're going to be talking about FISA, the Foreign Intelligence Surveillance Act, the Foreign Intelligence Surveillance Court, and whether the Justice Department and FBI may have been affected by politics when they surveilled members of the Trump campaign. We're also going to be talking about the recently released, heavily redacted FISA applications and FISA warrants related to former Trump campaign advisor Carter Page, Judicial Watch's role in helping force that release, and what Judicial Watch is continuing to do to uncover the truth surrounding all of these issues. And joining me today to discuss all of this and to shed some light on it is Judicial Watch attorney Michael Bekesha. So thank you very much for joining today, sir.
Thanks for having me.
So I've got the 412 some pages of the FISA application and FISA warrant related to Carter Page here. And as our viewers can see, it's a lot of paper and a lot of redactions. A lot of information is blacked out. So
what do you think's under there?
That's a great question. It's actually something that it seems like Judicial Watch wants to know. So before we dive into what Judicial Watch is doing to get the rest of this information, can you walk our viewers very briefly through sort of what FISA is, what the Foreign Intelligence Surveillance Court is, and sort of give us a framework for the rest of our conversation here?
Sure, I can try to, but it's going to be tough because it's a secret court. So FISA is a law that was passed in 1978 that allows the U.S. government to conduct electronic surveillance on agents of foreign countries within our borders. That could be U.S. citizens, or it could be citizens of other countries that happen to be here spying on us. However, because it's such a sensitive matter, Congress decided that we needed a separate court. We needed a different court from the basic district courts to handle it. And so they created what is loosely known as the FISA Court, but it's the Foreign Intelligence Surveillance Court. It is a secret court. There is no courthouse. There are no procedures really online about it. You can't find the docket. You can't go sit in on the court. And on it are 11 judges that are appointed by Chief Justice Roberts from other courts, and they sit for, I believe it's a 7-year term.
Now, when someone says that the proceedings there are ex parte, and they say that they are unchallenged by some sort of defense, I mean, talk with me a little bit about what we sort of know about the proceedings themselves, if we know anything.
We really don't. I mean, we know that if you're a target of a FISA application, you're not notified, you're not told. You know, ex parte just means the adversarial, the opposing party isn't there. And so it's just one party, which is the government, asking for a warrant, and the judge is going to say either yes or no. We do know since 1978, I believe the number is 99% of all FISA applications have been approved. So that's quite a few. It also seems to suggest there really isn't much process, or at least challenging what the government wants to do. I mean, if they're successful 99% of the time, I mean, if they want a warrant, they can get it.
Yeah, the stats that I was looking at, and they're varied, probably because of sort of the secret nature of the court itself, but something like tens of thousands of applications have been done, and maybe a dozen have been rejected. Maybe it's more than that, but it seems like it's something even closer to like 99.9%.
Yeah, I mean, the government says, the Justice Department says it's 99%.
Yeah.
They say it's somewhere, I believe it's under 50. Yeah, it's a very low number that's rejected, but we don't really know much about it. And, you know, when it comes to Carter Page, we know even less. And because of that, we have been using our tools to seek access to the information.
So let's talk. Let's get into that, and let's talk about how the FISA process and the FISA court, the Foreign Intelligence Surveillance Court, how that came to start to play a role in the presidential election in 2016. So we have some of this information. Some of it's released in the FISA applications and FISA warrants. But how did this court get involved with the Carter Page situation?
The Justice Department went to them and asked for them to approve a warrant application.
And so far, what do we know about how the Justice Department and FBI sort of justified their request?
Yeah, I mean, we know some stuff, but we don't know that much. I mean, as you showed, most of the application, I believe the first application, which was in October of 2016, that was the first time they sought an application related to Carter Page. It was approximately 76 pages long. Of that, 85% of it probably is redacted. And so we don't know as much as we should and we want to know. But what we do know is that the Justice Department had the dossier, and they used the information contained in the dossier, at least in part. We don't know how much of a role it played because we can't see the rest. But in part, they use that to justify seeking a warrant on Carter Page.
Talk with me about what we know about the dossier versus how the dossier was sort of presented in the application itself.
You know, I think what we know from the dossier was it was created by political opponents, people that did not want to see Donald Trump elected president. It was paid for by such individuals, primarily the Clinton campaign.
Yeah.
That is not explicitly spelled out in the material that we can see. It could be part of the redacted stuff, but it most likely isn't. But you know what I find most interesting, a little bit away from the dossier or who created the dossier, was the fact that the application materials that we found highlight really for the first time, or officially for the first time, that the State Department was heavily involved in the gathering of intelligence that was then used to seek the application.
So let's talk a little bit about that, actually, because I know that Judicial Watch has been trying to get sort of a broad scope on everything that went into the whole FISA process and how it all came to be. And we have lawsuits, I believe, related to the State Department, lawsuits related to the Central Intelligence Agency, as well as the Department of Justice. So can we get into that a little bit?
Sure. We have tons of litigation.
Yeah.
I mean, Judicial Watch is busy. We're really the only ones out there that are looking at this from every possible angle. You may hear Congress talk about it, but I'm not even sure they're doing as much as we are. And so we're looking in all the different places. So we're looking at the Justice Department. We're looking, we sued the Justice Department for this material. This material was released to us because we sued. And we're going to continue fighting for the material that's being redacted. We've also sent FOIA requests and a FOIA litigation against the State Department, asking for all the communications between Steele, the author of the dossier, and individuals within the State Department, including Secretary Clinton, Secretary Kerry, and one of the assistant secretaries, Newland, I think, is the name. We know there have been media reports that all of Steele's memos and work was being shared with the State Department, potentially hundreds of them, maybe even 1,000. Of material throughout the 8 years of the Obama administration. So we want to know more about that. We also, just this week, sued the FISA court, or sued within the FISA court, for the transcripts of the hearings. So, I talked a few minutes ago about how we don't know what the real procedure is. We don't know what actually goes on and takes place in the secret court. And we want to know. So we sent a request to the Justice Department asking for the transcripts of the hearings within the court about when they brought the applications to them. The Justice Department said they didn't have any transcripts. So now we sued the court. We asked the court to release those transcripts because it's of great public importance and we only have limited knowledge and we should have a full picture. And so just this week we sued the court and we're asking them, we have all this information. We have the Nunes memo, we have the Democratic memo, we have 412 pages of heavily redacted material. Now let's also see the transcripts. Let's see what the questions the judges were asking and what questions and what answers the Justice Department was providing.
Yeah, so I actually have our motion here with the Foreign Intelligence Surveillance Court. It is. Looks like it was put together by attorney Michael Bekesha, actually.
Yeah, I did that.
So
I had some help. We have, at Judicial Watch, we have legal interns for the summer.
Yeah.
And so we had a law school student also help out with it.
Awesome. So when you take a look at it, attached to the motion itself as exhibits, we actually find what's known as the Nunes memo, the House Intelligence Committee memo put together by the Republicans on the committee, and then I believe that you also attached the Democratic memo as well.
We do. We also attach a letter from the court to Congressman Nunes saying that the Justice Department may have the transcripts. So the Congress also asked the court for the transcripts, but because of separation of powers, the court said, well, we're not really sure if we can release it to you, but the Justice Department has them or can easily get them, so go ask them for it. And then we did that, and the Justice Department said, oh, we don't have them, so now we're going back to the court.
So our first line of trying to get this information was to ask the Justice Department for it.
Yes.
And we got kind of the...
We said, we're in litigation, and they said, we have no records.
Yeah. So the Justice Department claims that they have no records of the hearing transcripts for when they went and actually presented this information in front of the FISA court.
That's correct.
And we obviously want this because we would hope that there's some sort of hearing process or some sort of presentation in front of a judge where outside of what's written down, that there's actually an explanation given to a judge. I'm assuming that that's what our hope is.
Yeah, I mean, we assume that there's a full process where a judge seriously considers the application, asks tough questions, evaluates the evidence before the judge makes a decision to either grant or disapprove of the warrant. And you would think that because this is such an important issue, the surveillance of a U.S. citizen on U.S. territory, because the government believes that individual is a spy or an actor of a foreign government, that there would be a record of that hearing in that proceeding. And so we're asking the court to release it.
Yeah, and you'd especially hope it because the nature of the hearing, like we said earlier, is ex parte in the sense that there's no one there advocating for the defense. You've only got the Justice Department. So you'd hope, the hope is that the judge is at least asking some questions.
Right. I mean, I think that's what the American public believes the process is. And so if it's not, and we learn that there are no hearings or there are no transcripts because there are no hearings, that's going to be troubling. That's going to be a little bit disturbing, but I think it's something the public needs to know.
Yeah. So that's one line of sort of attack that we're using to try and get this information, trying to get it out of the the court itself. You mentioned the State Department. We believe that the State Department at least has some information was being provided, some information by Steele, and some of that is referenced in the in the redacted pages.
And then we have lawsuits against the Justice Department.
Yeah. Talk with me about what we're trying to get there. I believe that we've tried to get information related to Bruce Orr, who is a pretty high-ranking DOJ official, and information related to Fusion GPS, which was the organization that had hired.
Yeah, I mean, we're looking for everything.
Yeah.
I mean, we have numerous FOIA lawsuits. So we have numerous lawsuits in federal court here in Washington, D.C., asking for all different types of records about the investigation. And so with the State Department, it's asking for the FISA application specifically. It's asking for communications of senior level officials that was involved in the application process. It was asking for communications with Bruce Orr and Fusion GPS. Whatever you can think of, we're investigating it. We're going down those roads. We're looking for answers. And we're really not going to stop until we get them.
We also have a FOIA lawsuit related to the CIA and its potential involvement in having the dossier information, John Brennan potentially passing some of that information around. What are we doing there?
You know, we're trying to figure out who was talking to who, when, about what.
Yeah.
I mean, and that includes members of Congress, you know, so we want to know, well, it's members of Congress, it's also the media. What was being leaked? When was it going to be leaked? I mean, the one thing we want to know, and one thing that the dossier, or not the dossier, but the application materials still don't answer about the dossier, is was the dossier, you know, the only evidence they had, and then everything else that references it is supporting evidence. And you know, Tom was on Fox the other day. I think he talked about it as a self-licking ice cream cone or something.
Yeah.
You know, I'm not sure I fully understand that, but you know, but I mean, what he's saying and what we're looking for is, you know, is it all the same material? Is it really just one source of material that then was spreading that material around, and then they were using the other sources to bolster really the only source?
Right. So it's possible that all of the, you know, we just don't know. I mean, this is why we want the information, because there's all this blacked out information, and we know that the dossier was being passed around all these various different, you know, agencies, the State Department, CIA, Justice.
Yeah, I mean, look, the President of the United States, President Trump, can declassify those materials, and those materials could be released to the public immediately.
And we've been asking him to, I believe.
We've been asking him to do that. You know, Tom again was on Fox, I believe, Monday morning. The president was tweeting for everybody to tune in to watch Fox, and during that appearance, Tom said, we believe that the president should declassify this information.
Yeah.
And so it is important. We need to do, you know, the president needs to do that. We need to see what else is in there. And the only way that's really going to be done is by the declassification of all that blacked out material.
Yeah, and that's part of what we're fighting for. That's part of what we're asking for. What do you see our chances of success? I mean, so the reason why this is actually such a really interesting case is, as far as I can tell, this is the first time that FISA application, FISA warrant information has really been released by the court. So we're sort of in a unique sort of legal situation right now.
We are, but you know, the reason this material is released is because the president declassified the Nunes and the Democratic memo.
Right.
Had those memos not been declassified by the president, none of this material would have been made public. But because that information, the information contained in the memos, was declassified, the agencies, the government could go through that 412 pages and unredact the information that was in the other memos. So the president has already taken the first step.
Yeah.
We just need him to take the second step. And where does this go from here? I mean, Judicial Watch is going to continue fighting in federal court. We're going to continue attacking in all the different lawsuits, all the different points of entry. And in the end, we're going to shake information out. It's what we do, and it's what, you know, really only we can do. Yeah.
And I think that our lawsuits surrounding this information really did help in getting this information out there. I actually think that the president may have gone ahead and gave us some credit for the work that we were doing.
He did. Well, what happened was we recognized that when the memos were declassified, the 2 congressional memos were declassified, that means this information could now be made available to the public. So we sent the FOIA request, we sued, and then it was released to us over the weekend. So you're absolutely right. The president was absolutely right. Had it not been for Judicial Watch, we may have not received this information.
Yeah, and the hope is that we continue to have success there, and really hope that the president continues to declassify this information, because, like you said, we really think that the American public needs to know.
Absolutely.
Yeah. Well, Michael, I think you've really helped shed some light on it. Obviously,
hopefully.
Your legal expertise really helps break it down. So I appreciate you coming on, helping explain some of the FISA process, and helping explain sort of how Judicial Watch is trying to put the pieces together. So.
Absolutely. I hope you invite me back.
Yeah. Well, we'll see. Well, thanks again, Michael, and thank you all very much for joining in for this edition. To continue to follow Judicial Watch's work, to see what we're doing to get information out of the Justice Department, out of the State Department, out of the CIA. And to see what we can do in terms of getting information out of the Foreign Intelligence Surveillance Court as well, just continue to follow us, Facebook, Twitter, Instagram, YouTube. We're doing a lot of work. We have a lot of attorneys, a lot of investigators that are on the case, and you can count on us to continue. So until next time, I'm Jerry Dunleavy for Inside Judicial Watch. Thanks for joining.